students, welcome back to my channel. This is part 3 of Union Executive topic. In this part, I will teach you about Prime Minister and Council of Ministers. In previous 2 parts, I have taught you about President and the Vice President of India. If you didn't watch those videos, make sure to watch it first. Link is given below. This topic is very important for many competitive exams. So watch the entire video without skipping any clip. If you are new on my channel, then hit the subscribe button, click the bell icon so that you can get the notification of my new videos. If you like my video, then click the like button and share my video among maximum number of the people. Let us start the topic. First, we need to know about the provision of Prime Minister in Indian Constitution. According to Article 75 of Indian Constitution, the Prime Minister is one who is appointed by the President of India. Means the President of India will appoint the Prime Minister of India. But according to the Constitution, there is no specific procedure for election or appointment of the Prime Minister. According to Article 74(1), there shall be a Council of Ministers with Prime Minister at the head to act and advise the President of India. Means the Constitution itself recognizes a Council of Ministers. Who is eligible to be a Prime Minister? To become an Indian Prime Minister, one has to be a citizen of India, should be member of either houses of the parliament, should complete 30 years of age. If he or she is the member of the Rajya Sabha, he or she also can become the Prime Minister at the age of 25 years if he or she is the member of the Lok Sabha. If the person chosen as the Prime Minister is neither a member of the Lok Sabha nor the Rajya Sabha at the time of selection, he or she must become a member of either of the houses within 6 months of his or her appointment. Generally, Lok Sabha member became the Prime Minister of India. But sometimes some Rajya Sabha members also became the Prime Minister of India, like Indira Gandhi, Manmohan Singh. Indira Gandhi was the first Prime Minister who was the member of the Rajya Sabha. He or she should not hold any office of profit under the central government, state governments as well as local government. If the candidate holds the office of profit appointed as the Prime Minister of the country, then he or she must vacate from the post. Most importantly, the candidate should not hold any criminal charges proved in any court of justice in India. As far as appointment of the Prime Minister is concerned, the Prime Minister of India is appointed by the President of India through the provisions under Article 84 and Article 75 of Indian Constitution. The Prime Minister of India is the leader of majority party or coalition party of the Lok Sabha. When the party receives the majority in Lok Sabha, the leader of that party is called upon by the President to make the government, or the leader of coalition party who can win the confidence in Lok Sabha. The Prime Minister is also the real head of the country. In the appointment of the Prime Minister, the President also can use the discretionary power, but only when no party has clear majority in the Lok Sabha. Now we will see power and function of Prime Minister. This session is very important for exam perspective because oftenly questions come from this session in many competitive exams. As far as power and functions of Prime Minister is concerned, he performs his functions taking responsibilities as the Prime Minister proposes the names of the members to President for appointment as the ministers of the government. Constitutionally, President appoints the ministers of the government, but in reality, Prime Minister proposes the names of the members to the President. The Prime Minister has the authority to assign portfolios to the ministers. That's why he is also the head of the government. Because in India, there is parliamentary form of government. In parliamentary form of government, real head is different from the constitutional head. In India, President is the constitutional head and he is also the nominal head, and the Prime Minister is the real head and he is also the head of the government. He acts as the chief advisor to the President. He can advise the President to dissolve entire Lok Sabha to conduct fresh elections. As the chairman of the cabinet, the Prime Minister of India performs many duties, such as Prime Minister can reshuffle the cabinet and decides for the distribution of charges of different ministries as well. He suggests the President of India about the resignation or removal of any minister from the cabinet. He also directs and controls functioning of ministers in the cabinet. The Prime Minister may resign at any time and can even ask the President of India to dissolve the cabinet. The cabinet stops functioning if the Prime Minister resigns from his post and spontaneously dissolves after the death of the Prime Minister. Means the Cabinet of India revolves around the Prime Minister. Prime Minister can appoint the members, can remove the members. If he resigns, the entire cabinet stops functioning. While explaining the power and rights of the Indian president, we have seen that the Indian president appoints many dignitaries to Indian government. But in reality, the president of India can appoint these dignitaries after getting advice of the Prime Minister. Without advice of the Prime Minister, the President of India cannot appoint these dignitaries. So, in reality, the Prime Minister of India appoints these dignitaries, such as Controller and Auditor General of India, Attorney General of India, Advocate General of India, Chairman and members of UPSC, selection of election commissioners, members and chairman of the Finance Commission, and so on. The Prime Minister of India also has rights or powers with regard to Parliament of India. We know the Prime Minister of India is the leader of the Lok Sabha. Being a leader of the Lok Sabha, he has many rights or powers, such as the Prime Minister decides the foreign policy of the country. He is the Speaker of the central government. He is the leader of the majority party or coalition of parties in the Parliament. Apart from these, the Prime Minister is the chairman of various organizations including Niti Aayog, National Development Council, National Integration Council, Interstate Council, National Water Resources Council. He is also the head of the disaster management team during a political level emergency. He is also the political head of all the forces. But the constitutional head of all the forces is President of India. Now we will see some important articles with regard to relationship between the Prime Minister and the President of India, which is very important for exam perspective, and repeatedly questions have been asked from this session. Article 74 mentions how the Prime Minister and President are both connected with the Council of Ministers and Council with PM as head advise President on various issues. Then Article 75 mentions three things. First, President appoints PM and other ministers are appointed by the President on the advice of the PM. Ministers hold their office during the pleasure of the President. Then, Council of Ministers is collectively responsible to the Lok Sabha. This question is being asked many times, that in which article it is mentioned that Council of Ministers is collectively responsible to the Lok Sabha. Then Article 78, PM communicates all decisions made by the Council of Ministers to the President. President can also refer issues for the consideration of the Council of Members. Now we will discuss about the Council of Ministers. As we have discussed earlier, that in Article 74, it is clearly mentioned that there shall be a Council of Ministers to aid and advise the President. The Union Council of Ministers exercises executive authority in the Republic of India. The Council of Ministers must have a Prime Minister at the head to aid and advise the President. The President should exercise his function and act in accordance with advice rendered by the Council of Ministers. The Council of Ministers should reconsider any advice sent back by the President, but the President is bound to act in accordance with the advice tendered by the Council after reconsideration. The Council of Ministers comprises four different types of ministers. However, the Indian Constitution does not categorize ministers into rank, but in practice, there are four types of ministers. First is Cabinet Ministers. He is present and he participates in every meeting of the Cabinet. Then, Ministers of State with independent charge. He or she is a minister of a state who does not work under a cabinet minister. When any matter concerning his department is on the agenda of the cabinet, he is invited to attend the meeting. Then Minister of State. He is a minister who does not have independent charge of any department and works under a cabinet minister. The work to such minister is allotted by his cabinet minister. Then Deputy Minister. He is a minister who works under a cabinet minister or a minister of state with independent charge. His work is allotted by the minister under whom he is working. A smaller executive body called the Union Cabinet is the supreme decision-making body in India. Only the Prime Minister and ministers of the rank of Cabinet Ministers are members of the Union Cabinet in accordance with Article 75. People oftenly confuse between Cabinet and the Council of Ministers, and they assume the both as the same. So we need to differentiate between the Cabinet and Council of Ministers. The Cabinet is a smaller body consisting of 15 to 20 ministers. COM or Council of Ministers is a wider body consisting of 60 to 70 ministers. Cabinet includes the cabinet ministers only. Therefore, it is a part of the Council of Ministers. But in Council of Ministers, all three types of ministers are included. That is cabinet ministers, ministers of state, and deputy ministers. Cabinet exercises in practice the power of the Council of Ministers and thus acts for the latter. Council of Ministers doesn't act, so power vested with it are in theory. Usually, Cabinet meets as a body, frequently and usually once in a week, to deliberate and take decisions regarding the transaction of government business. Thus, it has collective functions. COM does not meet as a body to transact government business. It has no collective functions. Cabinet supervises the implementation of its decision by the Council of Ministers. Council of Ministers implements the decisions taken by the Cabinet. The term cabinet is not mentioned in the original text of the Indian Constitution. It was incorporated by the 44th Constitutional Amendment Act in Article 352 of the Constitution in 1978. Now also Article 352 only defines the cabinet, saying that it is the council consisting of the Prime Minister and other ministers of cabinet rank appointed under Article 75, and does not describe its powers and functions. In other words, its role in India's politico-administrative system is based on the conventions of parliamentary government as developed in Britain. As far as Council of Ministers is concerned, it is a constitutional body dealt in detail by the Articles 74 and 75 of the Constitution. However, the Constitution does not mention its size and classification. Its size is determined by the Prime Minister according to the exigencies of the time and requirements of the situation. Its classification into a three-tier body is based on the conventions of parliamentary government as developed in Britain. It has, however, got a legislative sanction. Thus, the Salaries and Allowances Act of 1952 defines a minister as a member of the Council of Ministers by whatever name called, and includes a deputy minister. Cabinet enforces the collective responsibility of the Council of Ministers to the lower house of Parliament. As far as Council of Ministers is concerned, it is collectively responsible to the lower house of the Parliament. As we have discussed earlier, the executive powers in India are exercised by the Council of Ministers. These ministers constitute ministries having cabinet minister, junior minister, etc. Before 2003, the size of ministries was not specified under any provision. After the 91st Amendment of the Constitution, it marked a ceiling limit to the size of the ministries. According to this Amendment Act, the strength of the Council of Ministers cannot exceed more than 15% of the total number of members of the Lok Sabha or relevant legislative assembly of the state. An exception was provided to the smaller states like Sikkim, Mizoram, and Goa, having a strength of lesser than 40 members in the legislative assemblies. It is also important to know about the dismissal or removal of a minister. The minister of the Lok Sabha can be removed from his post under the following conditions: upon the death of the minister, upon self-resignation from the minister, if the minister is dismissed by the president for unconstitutional his acts as per Article 75(2). Article 75 of the Constitution states that the minister holds the office at the pleasure of the president, upon direction from the court for committing the violation of any law. If the minister loses the eligibility to be a member of parliament. Now we will see the grounds on which the cabinet can be dismissed. The cabinet can be dissolved if the Prime Minister asks the President of India to dissolve the cabinet. The Prime Minister advises the President to dissolve entire Lok Sabha to conduct fresh elections. This happens only when the Prime Minister loses the confidence in the Lok Sabha. if the Prime Minister resigns from his post. It also happens when the Prime Minister loses his or her confidence in the Lok Sabha. The cabinet automatically dissolves after the death of the Prime Minister. The questions related to anti-defection laws are also very important for exam perspective. So you need to know precisely about the anti-defection laws. Disqualification on defection on the ground of a split in a political party. Article 102(2) and Article 191(2) provides for anti-defection laws regarding the members of Lok Sabha. According to this law, a member of a house belonging to any political party shall be disqualified as a member of the house on the following basis. If the person voluntarily gives up his/her membership of a political party to which he/she belongs, or if the person votes or abstains from voting in contrary to any direction issued by the political party or by any person or authority authorized to give directions. In either case, the prior permission of such political party, person or authority must be sought. The voting or abstention must be approved by the political party, person or authority within 15 days from the date of voting or abstention. When a member of a house claims that he and any other members of his party have formed a group representing a faction emerging as a result of a split in his original political party. If such a group consists of one-third or more of the members of such a political party, then the ministers cannot be disqualified under anti-defection laws. Now the question is, can a non-member become a minister? Article 75 of the Constitution of India provides for provisions relating to the appointment of the union ministers. At first, the Prime Minister is appointed by the President, and then the President appoints other ministers on the advice of the Prime Minister. The provision clearly states that any minister who is not a member of either house of the parliament shall cease to be a minister after the period of 6 months from the date of his appointment. The non-member must get elected to either house of the parliament in order to continue as a minister of Lok Sabha. Then the question arose whether a convicted can be appointed as chief minister or not. The issue was decided in the negative by the Supreme Court in the famous case of B.R. Kapoor versus State of Tamil Nadu. It was held that any person who is convicted for a criminal offence and sentenced to imprisonment for a period of 2 years or more cannot be appointed the chief minister of any state under Article 164(1) of the Indian Constitution. We also need to know how the Parliament of India can be dissolved. In our country, the Lok Sabha has a 5-year term, but it can be dissolved earlier. Article 83(2) of the Indian Constitution states that at the completion of 5 years term from the starting date of Lok Sabha meeting, it can be dissolved. In such cases, an election is held to elect the new members of parliament. The Lok Sabha can be dissolved by the President on the advice of Prime Minister before the expiry of its term. The President can also dissolve the Lok Sabha if he feels that a viable government cannot be formed after the resignation or fall of a regime, as the case may be. What is the principle of collective responsibility? The principle of collective responsibility means that the Council of Ministers is collectively responsible as a body for all the actions, omissions, and conduct of the government. It states that all ministers stand or fall together in parliament. The government is considered as a unity of ministers instead of single individual. It means that the minister should publicly support the decisions made by the cabinet, even if they disagree privately. This support even includes voting for government in the legislature. Apart from collective responsibility, the minister also has individual responsibility. The ministerial individual responsibility means that a cabinet minister is ultimately responsible for all the actions of his ministry or department. Whenever there is an individual ministerial responsibility, the party to which the minister is a part is not answerable for the failure of the minister. The minister shall himself take the blame for the actions of his ministry and resign. Thank you for watching my video. If you have any query, write in comment section.